I heard once a fellow argue that preparing for discovery after you've received a demand is like trying to learn to be a firefighter after your living room sofa has already caught fire. That at that point, if you don't start to plan for and respond to this before then, it's too late. You might succeed in putting out that particular fire without losing your entire house, but your sofa's gone, and probably so is your living room at a minimum. So would you say it's fair that to think of this in terms of something that you need to prepare for and that you need to be able to execute on, even if you don't have any reason right now to think that you're going to be the target of a suit?
Absolutely, absolutely. I mean, you have to be proactive in a lot of these things. In my business, I see a lot of people reactive. They
Right.
get in, they get sued, and they're in a panic. Their everyday business processes are completely disrupted because what happens, I mean, if you think about it, the worst thing that can happen if you're not prepared well enough for a discovery is that you lose your core case. I mean, honestly, there are cases that have had adverse judgments against them because they've inadvertently modified data, inadvertently, or they may have done it on purpose, some people, or they don't know where their data is, or they have email that they thought they didn't have and the other party has it. All these things can happen, and it disrupts your business. It disrupts, the adverse judgment. What happens when you lose a lawsuit? How much is that going to cost you?
How much do you have?
Exactly, and especially when you're doing things like intellectual property or something like that. So yes, to be proactive about it means in the long run you're saving time, money, and stress. I mean, I think people don't quite understand the importance of not stressing out, not having this absolute panic, which is what a lot, especially smaller businesses, have when they have this. Because a lot of times they don't have attorneys on staff. A lot of times they don't have the resources, if you will, that larger corporations have to deal with these things. So I think it's essential, especially for the smaller organization, to have the plan laid out ahead of time.
That's a good point. I think also it's important to understand that the FRCP has what lawyers call a safe harbor clause. And it basically, I'm not a lawyer, thank goodness, but basically what it says is if you are subject to a discovery requirement and you make a good faith effort to meet it, but you are missing or you lose some data due to routine conditions, in other words, if you're not losing data on purpose and you have otherwise tried hard to meet the requirements, that generally you will not be penalized for that.
To a certain extent. I think safe harbor, the problem with a lot of these rules is that you can read them two different ways. The one way is your very generous reading of it. The other way says that you have to have completely outlined what your routine business processes are. Basically says data that is lost during routine business processes should not be adversely against the litigant for that. However, as soon as you have notice of a lawsuit, not even notice, even when you suspect a lawsuit might be taking place, you must suspend those routine business processes. So that's
right.
where something like a retention policy comes in handy. So you don't, on one hand, as you said, if you're in good faith, doing this in good faith, especially if you're negotiating in good faith and you're talking to the other attorneys in good faith, that will definitely be in your favor. But at the same time, you have to be proactive about your retention policy. You have to be proactive about a litigation hold in that particular case when it starts. So safe harbor can work both ways. It really is a double-edged sword.
So I guess that's further argument in favor of consulting an attorney as you go through this process of planning how you're going to execute a new discovery
I would say
strategy.
when you're planning, I mean, theoretically, again, you can do this all kind of at home and do it yourself. There's a lot of resources on the net. Our website, sherpasoftware.com, is a good starting point. Also, Sedona Conference, EDRM.net. These are great places to start. So at least you have an idea. But we highly recommend, I think anybody who's coming up with their plans and their processes, retention policies, litigation hold processes, should have at least an attorney, especially one that has a little bit of knowledge in this area who has done it before. They should bring someone in to consult. But even if you don't, make sure you at least look at your peers in your industry.
Right.
See how they have handled it. Look on the internet, go in the different trade groups, and bring it up as a discussion point. How have you handled a situation like this? Because you'll see a bunch of different stories, a bunch of different experiences, and you can learn from those. So even if your organization is very small, doesn't have the resources perhaps to bring in outside consultants or what have you, at least become informed, understand what the terminology is, and designate people to help you with this. And if whoever's running your IT, whoever's running your business processes, talk to them about what you're learning, that sort of thing.
It sounds like this kind of planning is cheap insurance going forward that everybody should do, even if you're absolutely certain that nobody's ever going to sue you and there's You'll never investigate anybody. None of the things you talked about are ever going to happen. In Fantasyland, it sounds like becoming knowledgeable and planning just in case is a smart thing to do.
Yeah, and honestly, business processes, if you have good processes in place, you should already have these things there. I mean, even outside of e-discovery, you should have a retention policy. You should have a policy, what happens, for example, if an employee is terminated. What do you do with their data? You know, is it sitting there for years and years? Do you have it in a place just in case they sue the company or come back for a different reason? I mean, these processes cannot just help with e-discovery, but they can help your day-to-day business.
Right. That's a good point.